Good morning. My name is Anna Lee, and I work at Vermont Legal Aid in the Office of the Healthcare Advocate. Vermont Legal Aid is a nonprofit law firm that provides civil legal aid. Civil legal issues include things like housing, healthcare, disability law, and senior law. You can find more information on our joint website with Legal Services Vermont, which is www.vtlawhelp.org. Thank you for joining us today. Our town hall includes a guest, and you'll be able to ask questions of our guest. If you are joining us on Zoom, you can click on the Q&A button in Zoom, where you can type in your questions, and I will ask them out loud. You will also get a written answer to your question from our moderators. If you're joining us on Facebook Live, you can type questions into the Facebook Live comments, and I will also read those out loud. Plus, you'll get a written response on Facebook from the moderators after the town hall. If you are calling in or listening over the phone, we don't have a way for you to ask questions from the phone during the live stream, but you can always call Vermont Legal Aid at 1-800-889-2047 to speak with a Vermont Legal Aid or Legal Services Vermont paralegal or attorney for confidential help. You can also find answers on our website, which is again, vtlawhelp.org. Our topic today is about unemployment benefits, and we covered general information about applying for unemployment, especially during COVID with those COVID-related changes to who can apply and be found eligible, extensively in our previous unemployment town hall on April 23rd. So if you have general questions about applying for unemployment, you can go back and watch the recording of that town hall on the Vermont Legal Aid Facebook page or YouTube. And again, that was the Unemployment Town Hall on April 23rd. Our guest today is Kelli Kazmarski. Kelli, thank you for joining us.
My pleasure. Thank you. My name's Kelli Kazmarski, as Annalee said. I'm a staff attorney at Vermont Legal Aid in the Poverty Law Project, and I work in the St. Johnsbury office when we are working from our offices.
Great, thanks for that introduction, Kelli. Today we're going to focus our talk on changes that have come with updates to unemployment benefits since our April town hall, like new federal updates, offers to return to work as Vermont starts to reopen, appealing denials, and overpayments. So Kelli, let's start off with just, have there been any changes to the unemployment benefits since that $600 a week extra unemployment ended on July 31st?
Well, certainly that was a big change for folks. And just to briefly review, that $600 a week that people were getting through the end of July was called PUC, or Pandemic Unemployment Compensation. What continues to be available for people now is either regular unemployment insurance, regular UI, or the PUA, which is the Pandemic Unemployment Assistance, which provides unemployment benefits for people who didn't traditionally qualify for unemployment, people who were, for example, self-employed or extreme part-time workers or independent contractors. And so this past weekend, people may have heard that President Trump did sign some memoranda and executive orders that apparently do extend unemployment benefits. There are still quite a few questions about what that will actually look like. I have read that it would be an extension of the PUC or in some form. It looks like it might be $300 or perhaps $400 a week. It's not clear, I don't think yet, when it will begin, how much it will be. And I think one of the issues is whether the federal government or state governments will have to pay some of that or $400. So we'll see. I hope in the very near future this will become clear. We are not at this moment sure how any of the president's new initiatives will affect Vermonters. So we are still working on that.
Okay, so there is a new order that came from President Trump that maybe has extended some of that PUC extra money a week, but we're not sure what that's going to look like or how it'll function, but we will keep people updated on our website and our materials about how that will affect Vermonters when we have some new information about it.
Absolutely.
Great. Let's talk about the application process as it stands now. Have there been any changes to how people can apply for unemployment since we last did our town hall in April?
One of the changes that's occurred is that when people now initiate a claim or apply online, they will have to provide a driver's license. And that's because there was quite a bit of fraud that the Department of Labor apparently uncovered coming out of Nigeria. I believe people were applying for benefits and unfortunately getting through online. So the department added this security level of requiring a driver's license if you're going to apply online. If you do not have a driver's license, you will need to call in to apply. So the two methods that are still available are to apply either online or by phone. If you don't have a computer or you don't have a driver's license, you will have to call. The claimant assistance line, we will put that maybe in our Q&A section so that people can see that. But the Department of Labor has hired over 100 people now to answer the phone. It's not like it used to be. I'm told wait times are down to about 20 seconds at the most. So folks should not have trouble getting through, certainly not like the horror stories we were hearing back in March and April when people were calling hundreds and thousands of times and not getting through. That's no longer the case. Again, people can apply online or by phone. And if you do apply by phone, it should be a much easier process to get through.
Okay, so if you're applying online, you need a driver's license. You can apply online at the Department of Labor website, which is labor.vermont.gov. If you don't have a driver's license or a way to apply online, you can still call and apply. Wait time should be much lower now that they've hired so many new folks to answer the phones. The claimant assistance number you can call is 877-214-3332. And let's talk about, now that we've had a while where folks are applying, what are some common issues that we're running into or seeing folks run into when they're getting through with that application?
One of the things that we are seeing fairly frequently is that people apply and they're just not hearing about a determination, or they're not hearing a decision, which the department calls a determination. It depends, the reasons for this vary, but generally speaking, it will take some time for people to get a decision. A couple of weeks is not uncommon simply because of the volume that the department is dealing with. But if somebody is waiting more than 30 days to get a decision, they should probably call the Department of Labor, the claimant assistance line, to see if they can find out the reasons for the delay. Before doing that, they could check the Department of Labor's portal for claimants. If you have access to the internet, that would probably be the best thing to do, and the first thing a person should do if they're not getting a decision. If that doesn't yield any information, you should probably try to call the claimant assistance line just to see what's happening. But that is something we are seeing. It can mean sometimes the claim is stuck in what's called adjudications, where they're trying to get some more information before they can make a decision. So it would vary from case to case why it's happening.
Okay, so if people are waiting a long time and they haven't heard anything, you can check the online portal to see the status of your claim, call claimant assistance. And because it can take a few weeks for the Department of Labor to make a decision, you should expect to hear back before that. But if you're waiting more than 30 days, that's when you would want to maybe give us a call at Vermont Legal Aid, which our number is 1-800-889-2047, because there could be something else going on that you'd want someone to look into. And what are some of the common reasons that could cause a delay for those benefits to be decided on, to be in that adjudication phase you talked about?
So sometimes cases are referred to adjudications, which means that a claims adjudicator needs to get involved. It could be something as simple as a mismatch of information that the employer provided. Is slightly different from what the claimant provided. It could be the rate of pay is off, or the date of the last date worked is off. Or sometimes it's something a little more significant. For example, the claimant is saying that they left work for a COVID-related reason, and the employer is saying that the person was fired for misconduct. In that case, a claims adjudicator would need to interview both the employer and the claimant to try to then learn the facts and make a decision at that point.
Okay, so it could just be a simple issue where something doesn't match up, or something a little bit more complicated where there's a dispute between you and the employer over why you left the job.
Mm-hmm.
Now, you mentioned a little bit before that there are some different types of unemployment depending on what kind of work people had done and if they would have been qualified for unemployment before any of the COVID changes.
Mm-hmm.
Do people need to do anything special if they're applying for regular unemployment or that special pandemic unemployment that was created for people who wouldn't usually be eligible?
Yeah, good question. So you don't need to do anything special. If you are applying online, when you go to the Department of Labor website, the website will guide you through the process. You would click on the link for applying for unemployment, and then there are two separate links depending on whether you have already applied for regular unemployment or have not already applied for regular unemployment. Because the first step in applying for the PUA is to establish that you're not eligible for the regular unemployment. And the website will guide you through that. And once you have begun the application process and are determined ineligible for regular UI, you should receive an email from the department prompting you to then apply for the PUA. And sometimes people don't receive that email, and that is sometimes an issue. It might be, again, something as simple as the department is missing a good email address, or it could be something more significant that the department has not yet determined whether you are eligible for PUA. And so again, it might be under review, the claim. If you can check the status of your situation, again, through that portal available through the Department of Labor website, and sometimes it will say under review on the PUA claim, which means that, again, there's an issue, as I mentioned before, if someone is fired for misconduct, that would not make them eligible for PUA, because you have to have unemployment related to COVID-19 in order to qualify for PUA. So if somebody is not getting that email, there could be a few reasons why that's happening, but that is the process generally for applying.
Okay, so people will apply for unemployment benefits, and if the department finds that they're not eligible for the regular unemployment, but thinks that you may be eligible for the PUA, they'll send you an email with the instructions on how to apply for the PUA. But you have to apply for regular unemployment first.
Mm-hmm.
And it sounds like if you don't get that email, You should check your portal to see if there's a status, because it could be that the department needs some more information before they can decide if you can apply for the PUA.
Mhm.
If folks are getting that unemployment denial, but not the email for applying for PUA, does it make sense that they would want to appeal that denial?
It definitely makes sense. I would caution people, though, to think about the one issue that is tricky. When the department makes a decision, you have 30 days to appeal that decision if you do not agree with it. In the case of someone who has lost employment due to COVID or become unemployed, even partially or fully due to COVID, in that situation, a person wants to be denied for regular UI, and appealing that denial will delay the processing of the PUA application because it would be seen as an open UI claim still. The decision would not be final if you appealed that denial. So if a person is certain that their unemployment is directly related to the virus and they have been denied regular UI, I would caution them about appealing, only because that would, again, delay the PUA application. If someone is in that situation, I would encourage them to check the portal and check the status of their claim, to contact the claimant assistance line, and pursue that first before filing an appeal. Of course, when the 30-day deadline has passed, then you are not generally able to appeal a decision. So if you need help deciding about whether or not to appeal, I would encourage you to consult our website. And if that doesn't help, give us a call at Legal Aid.
Okay, so when it comes to that denial of the unemployment, because you wouldn't be eligible and you know you need to apply for PUA, you're just waiting for them to send you that email. You
Right.
should apply the denial of unemployment, just wait for the email. If you're not sure if you should be eligible for the PUA and you're not sure if you should appeal, you should look at our website, which has information about this. And again, that's vtlawhelp.org. Or you can give us a call if you don't find the information there. And the number you can reach us at is 800-889-2047. And we talked a little bit about the appeals process and how it might not make sense for appealing the denial of the UI when you're waiting to apply for the PUA. But what should people know about how that appeals process works in case they do need to appeal their denial of the unemployment in other situations?
Well, again, the deadline, the 30-day deadline, is an important piece to remember. And if there is something in the decision that you do not agree with, then I would encourage you, or the claimant, I guess I should say, to appeal. The appeal must be done in writing. So there's really two things that are important to remember, and that's the 30-day deadline, and that it must be received, it must be in writing and received by the department within that 30 days. The appeal can be sent by email, by fax, a handwritten note or letter mailed, old-fashioned snail mail would also do it. There's also a form in the claimant assistance handbook that people receive when they apply for benefits. And folks can use that form if they feel comfortable. But there's no real magic language to asking for an appeal. All that's necessary is that in writing, you indicate that you disagree with the decision. And it would be good to indicate what decision that is, the date that decision was made, and then be sure that someone reading can tell who sent it. So you should put your name, an address, a phone number, and even the last 4 digits of your social security number would be helpful. But again, a simple sentence saying, I would like to appeal the decision of such and such a date is sufficient, as long as the department can tell who sent that in and it's in writing and done within the 30 days.
Okay, so you have to submit your appeal in writing within 30 days. There's no magic language that you have to use. Just one sentence saying you want to appeal is okay. You can send that in with email. It's labor.appeals@vermont.gov. You can fax it, and their fax number is 802-828-4289. Or you could mail it to Department of Labor Appeals, P.O. Box 488, Montpelier, Vermont 05601-0488. What happens after you send in your appeal in those 30 days in writing?
Generally, you would then receive a confirmation from the department that they received your appeal. Particularly if you appeal by email, you probably get a response email, although not everyone is receiving those now simply because of the volume of appeals and emails just going into the Department of Labor. I still think emailing is a good way to appeal, even though there's a huge number of emails flooding in right now to the Department of Labor. But email is a good way to have a record of exactly when you appealed, because in your sent mail, you would have a copy, including the date and time that the appeal was sent in. So it's kind of nice to have that proof readily available if that becomes an issue. If your email is kind of stuck at the bottom of a pile and it takes a while for the department to get to it, that will be frustrating to wait, but there'd be no concern about the timeliness of your appeal. It would just be a matter of waiting for them to get to it. Once that happens, they will process your appeal and you will receive an appeal packet in the mail. Usually, you should receive it at least 7 days before a hearing is scheduled with an administrative law judge. So the appeal packet will have a notice of hearing, and it will have any documents that the judge will be considering at the hearing. So whatever documents the department has already. These might include notes that the claims adjudicator took during interviews. It might include information from the employer, information from the department that it generates different reports. But that whole packet will be sent a week before the hearing.
Okay, so once the department gets your request for an appeal, they'll send you confirmation in an email or a letter, depending on how you sent your appeal in. And you'll get to see all the evidence that they have already that they'll use at that appeal. What is the appeal hearing like with that? It sounds administrative law judge. Is that the person who listens to your appeal?
That's correct. The ALJ, or administrative law judge, will be on the phone with you. These hearings have been phone hearings since long before the virus. So it's not a new process. They're very used to conducting these on the phone, and they are meant to be more informal conversations with the judge. It's not like a formal court proceeding, so folks really can participate effectively without an attorney. That's how it's intended to be. You do have a right to have an attorney present, but you are certainly able to participate fully without an attorney. Everything is conducted in layperson's language. There's no legalese spoken. And again, I tell people frequently that it's really more like a conversation with the judge. The judge is taking a fresh look at the case. They are not bound by the decision that the claims adjudicator made in any way. So they will look at all the evidence and hear any new evidence as well. You can provide testimony. You can have witnesses on the phone with you to say what they know about the situation. You can also provide documentary evidence to the judge. Any documents have to be submitted at least 24 business hours before the hearing. They have to go to the judge and to the employer. But the judge then considers all of this evidence and issues a new decision, and can either uphold, reverse, modify the decision of the claims adjudicator.
Okay, so it's designed to be an informal phone hearing. You tell your side of the story to the judge will listen to any of your testimony or look at the documents that you submit in writing. Those have to be in at least 24 hours before the hearing.
Mhm.
And when you're going through that process, you don't need to have an attorney. But if you want help with that, you can look at our website or you can give us a call. We usually don't do full representation at this ALJ hearing because we don't have enough resources, but we'll help you prepare for it. So if you need help or you have questions about the process, you can give us a call at 1-800-889-2047. So you go through that hearing and the judge makes a decision. What happens if the judge doesn't decide in your favor? Can you appeal again?
Yes, there are actually two further levels of appeal. If you don't agree with the ALJ's decision, you can appeal to the Employment Security Board. This is a review panel. There are 3 members on the board. They will not hear any new evidence. So any hearing before the Employment Security Board is really about legal arguments about why the decision of the judge, the ALJ, was incorrect. There's no new evidence. The board can send a case back to an ALJ if it determines that more evidence is needed in the case. So that's one option, or they can uphold or reverse the decision of the ALJ. And then if you do not agree with the Employment Security Board decision, the final level of appeal is to the Vermont Supreme Court, which again is an opportunity for legal argument only. No new evidence can be admitted at that point. That is a much more complicated process, but it is available to people as well.
Okay, so it's really important to get any new evidence that you want considered in at that ALJ level.
That's correct,
because
yes.
you can appeal after that, but there's no new evidence, and the appeals would be for the Employment Securities Board. And if you disagree with that decision, you can appeal again to the Vermont Supreme Court.
That's
And
correct.
again, if you have questions about those processes, you can contact Vermont Legal Aid and Legal Services Vermont for help at that level. Our number again, 1-800-889-2047. And now that we're starting to see some changes with reopening in Vermont, what are some common appeal issues we're seeing as people are having changes with their unemployment eligibility?
A big issue that we're seeing right now has to do with refusals of suitable offers of work. This is also connected a little bit with the idea of a voluntary quit. Normally, if a person quits a job, they are not entitled to unemployment benefits. Unless the quit is related to something the employer did or the fault of the employer, and that's on the claimant to prove. But now during this pandemic, the legislature has amended the statute so that if somebody quits a job for COVID-related reasons, that would not disqualify them from receiving unemployment benefits. It is sort of understood that if somebody refuses a job for COVID-related reasons, that also would not disqualify them from benefits. Because again, normally, if someone is offered a job that is within the pay range that they would accept, that is the kind of job they were, have the hours that they were looking for, they really have to accept that job or they will lose unemployment benefits, usually. But now it is sort of understood that if somebody has an underlying health condition, for example, that puts them at higher risk so that they can't go back out into the workforce, it's understood that they should continue to get benefits. The problem is that our statute has not yet been amended to include all of the COVID-related reasons that are specifically listed in the voluntary quit section of the statute. Those have not yet been incorporated into the refusal of work part of the statute. So if somebody can't take a job because, for example, They have worries about their child's school situation, or they don't have daycare. We do anticipate there's going to be some issues that may come up around this, and around eligibility for benefits. We believe that people should be eligible for benefits if they, again, have a COVID-related reason for being under or unemployed, or refusing work. But a lot of these cases are going to come down to very specific facts. For example, if a school has reopened and the school has certain measures in place for safety, but a parent feels those measures aren't safe enough and chooses to keep their child home, and because of that cannot work, it's unclear how the department will treat that, whether that would be considered a something that would allow a person to continue to receive benefits or not. So I think a lot of these issues still sort of remain to be seen, and they're very much fact specific. So they're going to vary greatly from case to case, I believe.
Okay, so at the beginning of COVID, when people were having to leave jobs because their kids' daycares or schools were closed, or they had health conditions, the Vermont legislature changed the statute that says that if you quit a job, you can't get unemployment regularly. They changed that so that there were exceptions for COVID-related reasons where people could quit their job because of a COVID reason and continue to get unemployment. But now what we're running into is the statute that says that if you refuse an offer to return to work, then you can't get unemployment. They didn't change that statute for those COVID-related exceptions. So now there's questions about if people can't go back to work because their child's school is still closed, or they're still, because of their health, not able to be out and about because of concerns of COVID. So it's going to be very specific depending case to case on whether or not people are going to be able to refuse an offer to go back to work and still be eligible for unemployment. Am I understanding that right?
Yes, and I would encourage people who have questions about this to look at our website. We will continue to update materials at the vtlawhelp.org website, and also to look at the Department of Labor website. They have an FAQ section that might be very helpful for people who are trying to find out information about whether their eligibility would continue if they refused an offer of work. So I would really encourage folks to check out those two sources of information. And then if they still have questions or concerns, to give us a call.
Okay, so people will have to look at their individual circumstances, keep checking our website, check the Department of Labor's website. With these case-by-case issues where people are refusing to go back to work for COVID-related reasons, what can people expect to have to do to show that they're refusing work for a COVID-related reason?
I would expect that claims adjudicators would be getting involved and wanting to know more information about why a person refused an offer of work. So someone should expect that they'd be contacted by a claims adjudicator. They may want to, in advance, line up, for example, if a doctor has recommended that they stay home or that their child stay home for some reason, it would be maybe a good idea to start getting a letter from the doctor that shows that recommendation. So if somebody is planning to refuse a job, they should expect to hear from the Department of Labor about why. They also may just get denied unemployment at first. And if they believe that they have a good reason or a reason that is related to the virus for refusing work, and that might include an employer, for example, who's refusing to follow guidelines. That might be a reason to refuse an offer of work. But a claims adjudicator may still deny an initial application. I'm sorry, may still say that because you refused work, you're no longer eligible for benefits. That's something that could happen. And so a person should be prepared to appeal that if they feel that they do have a good reason for refusing an offer of work. I would imagine there's going to be a lot of appeals around this issue. So it probably is something people will have to look at.
Okay, so people, if they know that they're refusing work because of a COVID-related reason, should be prepared to submit evidence like a doctor's note when they're applying for unemployment, or in that claims adjudicator reaching out for more information, or even in an appeal process.
Yes.
We're starting to get some questions from the audience, and this one fits in neatly here. Someone is wondering about the hybrid school schedules where kids are in school for 2 days a week and out for 3. Do we think that parents who have to reduce their hours to stay home on those days will be able to get unemployment for those days of the week when they can't go to work?
I think that's a very reasonable, yes, that would make a lot of sense to me, that if a school has made a decision where they're actually not open for a few days a week, which then requires the parent to be home if there's no daycare, for example, available. And I think I think there's going to be some interesting issues that we'll have to go through the appeals process. For example, a parent who, a question that may come up is whether or not there is daycare available for that child. And if there is daycare available, then does that parent still have the right to refuse a job to stay home with that child and collect unemployment benefits? And I think the answer to that would depend, again, on the facts of the situation. There's going to be, I think, a lot of interesting issues coming out of this. And I don't know exactly how it will end up.
Okay, so a question like that, that's one of those case-by-case situations where you'd really want to take a look at the situation and all the facts.
Right, but I do think
Yeah.
that there is a legitimate argument to be made that that person, what would happen is that they would file a weekly claim, and then they would have to also indicate the wages that they earned for the days that they did work. And so that does to some degree change my answer, because if a person with the time that they are still working, let's say they're working 3 out of 5 days a week, if the wages that they earn for those 3 days of work are more than double the weekly benefit amount that they would receive in unemployment, then they probably would not get benefits for those weeks. And that's just a general rule across the board. When you make a weekly claim, you have to also indicate any wages that you have earned, and half of those wages are deducted from your weekly benefit amount. So if you earn more than twice your weekly benefit amount, there's no unemployment to be had. And I believe there's a specific rule that says you're not eligible in that situation. So I guess that slightly changes my answer, that I think it would depend again on the wages earned. But certainly that's an issue to look at, and I guess it would depend on the facts.
Okay, and if someone in that situation wanted to call us or look on our website for more information, they certainly could do that. Again, our website is the vtlawhelp.org, or our phone number is 1-800-889-2047. Let's switch gears just a little bit in the time we have left, and let's talk about some of the issues that come up when people have already started receiving unemployment. Mm-hmm. What are we seeing now that folks have been receiving unemployment for a long time, since March or April? Are there new issues coming up?
Yes, definitely. The biggest thing that we're seeing are overpayments are being, so people will receive a decision. So in the example I gave earlier, if someone refuses an offer of suitable work, but the department doesn't find out about that for a little while, they will continue to receive benefits. And then once the department learns of the refusal, there will be a notice issued saying you're no longer eligible. And by the way, we paid you for weeks that you should not have received benefits, so you now need to pay those back. And we are seeing a lot of these for various reasons. I've seen a few where the department has reevaluated a claim and said, oh, it looks like you quit your job, and so you shouldn't have received benefits, and you have a big overpayment. Now, remember, people were getting that additional $600 a week for a while, so these overpayments can look very large and scary. Well, it's a lot of money that people are now, the department is saying, has to be paid back. And that is definitely a concern, obviously. Some of these cases, though, that we're seeing are relatively simple matters. For example, yes, somebody quit back in April, but they quit for a COVID-related reason. And maybe a note from the doctor just hadn't made its way into the file at labor in time. Or it could be some other relatively minor issue that can be cleared up with an appeal. Unfortunately, usually once those decisions are made, the only way to change it is to appeal that decision and have the administrative law judge take a look at the case. But there are definitely cases that we have seen at Legal Aid that are looking like a fairly easy matter to fix with an appeal, just a matter of some missing information perhaps. But overpayments are definitely an issue. One of the biggest concerns with overpayments are that they often come with a penalty. So if somebody receives benefits they shouldn't have, they have to be paid back. That's an overpayment of benefits. If the department finds that the overpayment was caused by a person's intentional misrepresentation or failure to report information, then the department adds on a 15% penalty, a financial penalty, and also adds in what are called penalty weeks, so that the next time this person has to go and apply for unemployment, they will find that they are not eligible because of these penalty weeks. And unfortunately, these have come back to haunt people right now during the pandemic. We've had many people who had this problem 8 or 10 years ago and are only now finding out about these penalty weeks that they have to serve. So if somebody gets a notice about an overpayment that includes this penalty for intentional misrepresentation, essentially fraud, we encourage folks to appeal those. Often, most of the time, in fact, I don't know really of one that I would not have encouraged a person to appeal. Most of the time, it's a mistake. Yes, there may have been an error, and yes, the money does need to eventually be paid back because maybe benefits were received in error. But the penalty part, the intentional misrepresentation, often is not true, and the state needs to prove that if they're going to make that finding, and they have to prove it by clear and convincing evidence, and often that evidence is not there. So if someone gets a notice of overpayment, they should really pay attention to whether there's that penalty. And if there is, they should appeal that because removing just the penalty part even is a significant achievement, and especially for the future impact on benefits they may need in the future.
Okay, so now that we are a few months into this, people are starting to get notices that maybe in March or April, when this crisis started and they applied for unemployment, started getting benefits, the department has gone back and said, we have found out you should not have been eligible for those benefits. We need you to pay those back now. Mm-hmm. And with that, sometimes it's just a mistake and people can clear that up, but they might need to go through an appeal in order to present their new evidence, like a doctor's note or proof that their child's school closed, to show that they were eligible. The other issue that can come up is if the Department of Labor thinks that there was intentional fraud on someone's behalf, where it wasn't a mistake, it was just they meant to collect those benefits when they weren't eligible. There's not only do you have to pay the benefits back, but they'll also have penalty weeks built in, where the next time you go and apply for unemployment, even if that's 5 or 10 years in the future, you would have to wait some penalty weeks before you could start collecting benefits. And if you get a notice now that says that you've had an overpayment, so you have to pay the benefits back and you'll have to serve those penalty weeks, it's important that you appeal that decision so that you don't run into penalty weeks in the future, because most of the time it's going to be really hard for the department to prove that you committed fraud. They have to have really strong evidence of it. And most of the time it was just a mistake and it wasn't intentional or anything like that. So pay lots of attention to the appeal timelines. And if there's something in your notice about an overpayment and penalty, you want to keep an eye on that for appealing. Would there be any reason that someone would not want to appeal a decision by the Department of Labor? Is there any kind of downside to appealing?
Except for the situation that we talked about earlier, where somebody has been denied regular UI, but believes that they are eligible for the PUA because they are unemployed for pandemic-related reasons. That's really the only case that I would caution someone about appealing. Otherwise, if a person disagrees with the decision, they have the right to appeal. And so, appeals can be withdrawn later if somebody realizes that, oh, I guess really I wasn't supposed to get benefits. I guess that was a correct decision. So sometimes that might happen where the appeal deadline is approaching. Someone is not sure, they disagree with the decision, so they file an appeal, and then maybe a few days later speak with an attorney at legal aid who tells them, really, this was the correct decision according to the law. That person then might decide to withdraw their appeal. And they could do that. They also may decide to go forward with the appeal because they believe strongly that they have a good argument to make, and that is a person's right to proceed with the appeal. So we encourage folks to do that, even if our opinion is that, that the decision was correct according to the law. Someone still has the right to appeal and should do so if they want to.
Okay, so there's no downside to appealing other than if you're appealing a denial of unemployment when you should be applying for PUA instead. So you always have the right to appeal, and you can withdraw an appeal after you've submitted it if you decide after all that you don't want to go through the process. And we're coming to the end of our time here, so I just want to summarize, what should people do if they're having problems with applying, appealing, getting information? What are the steps they should take for their application or an appeal?
The first thing I'd really encourage folks to do is get all of the documents that they have from the Department of Labor, put them in chronological order, and just read them again. Many people I talked to, missed important information on these documents. There is a lot there, particularly on decisions, notices of hearing. There's a lot of information there, and you might be able to answer your questions just by looking at the Department of Labor documents. I would encourage people to go to our website, the Department of Labor website, and see if they can answer their questions there. And then finally, the other thing I would encourage people to do is to check the claimant portal through the Department of Labor website. That can sometimes provide answers about why there's a delay with a claim. There's a chat option even available on the Department of Labor website where you can live chat with someone at the Department of Labor. That might be a way to have questions answered as well. And then I guess if a person is not able to answer a question by any of those means, they can give us a call, and one of our advocates will get back to them to try to help them through whatever is causing concern.
All right, so steps people can take if they're applying or appealing and having questions or issues. You should gather up all your documents, look for dates, information about appeals, timelines, anything like that. You can also check the online portal to look at the status of your claim, and that's with the Department of Labor's website. You can also read more information on the Department of Labor website and our website. Again, those website for the Department of Labor, it's labor.vermont.gov. And the website for Legal Services Vermont and Vermont Legal Aid is vtlawhelp.org. And a lot of FAQs, lots of information on those websites that might be able to answer your questions. But if you're still not able to answer your questions with that website information, you can give us a call at 1-800-889-2047. And one other piece to note is that if you are waiting for information from Department of Labor, keep in mind that 30-day deadline for appeals. So if you're getting close to that deadline, you might want to submit something just because you can always withdraw it later. Or also, if you are waiting for information and it hasn't been 30 days for the Department of Labor to process your claim, you might need to just check that portal, see if there's any information there, because usually it's taking them a few weeks to process information. So other than that appeal, which is that 30-day deadline, before that, you might want to check the websites for more information before you give us a call. As far as our question and answer period, we had a few questions sprinkled in there, but this one I thought fit nicely at the end. This is someone who's wondering, because the regular benefits for unemployment were extended, they're wondering if there's a possibility that they will be extended a second time. Do we have any information about if there's upcoming extensions for unemployment benefits?
At this point, I'm not hearing anything. It is certainly possible that benefits could be extended again. So the legislature passed the Pandemic Emergency Unemployment Compensation, PEUC, which added 13 weeks onto the regular unemployment claim. So normally unemployment lasts for 26 weeks. It now lasts for 39 weeks with the extension. And the PUA already also lasts for 39 weeks. And it is possible that there could be another extension added on. And another possibility is that we go into just a period of extended benefits, which is already available as a process that the Department of Labor can go to. But the legislature may also extend these emergency provisions. Anything is possible. We'll have to see what happens this fall. I really think a lot is going to depend on, the course of the virus and how the pandemic, you can hear some sort of scary news, and sometimes you hear good news depending on what source you're listening to. But we will try to keep our website updated with new information as soon as we find out any new information. And that includes when we learn more about how the president's recent actions will impact Vermonters, or certainly if there's any new legislation that comes down extending benefits, we will try to keep our website updated as quickly as we can.
Okay, so we don't know for sure if anything's going to be extended at this point, but we are keeping an eye on the situation, and people can always check our website, which again, it's our joint website with Legal Services Vermont, and that's vtlawhelp.org. If they have questions about the newest updates or if they hear anything and they want to fact check it. So I think we don't have any more questions. Thank you so much for taking the time out to present to us today, Kelli. We appreciate all your expertise, and thank you so much to everyone who joined our town hall today.
Thank you.